You know, we can't move forward until I put this next discovery thing out.
Okay. Jefferson County Court Law number 2 is back in session. Court is in session with trial docket. First 6 cases on cause number M325966, cause number M322358, cause number M333400, cause number M33398, cause number M331524, and cause number M331522. All 6 cases are style of state of Texas versus Alfonso Vasquez. Mr. Vasquez, is that your full name?
Yes,
Mr. Vasquez, would you please raise your right hand? Mr. Vasquez, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
sir.
Mr. Vasquez, you may put your hand down. How are you doing, Mr. Vasquez? That's good. Now, well, I'm doing good. I'm doing good. Thanks for asking. Mr. Vasquez, you're represented in your case by your attorney, Tom Burbank. Attorney Burbank, how are you doing?
Fine.
And Mr. Burbank, do you have a record in Mr. Vasquez cases?
We do.
Okay. And the state is represented in this case by Attorney Kobe Hoffbar. Attorney Hoffbar, how are you doing?
Good job.
Mr. Vasquez, in cause number M325966, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Alfonso Vasquez, on or about February 1st of 2020, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of driving while intoxicated. Mr. Vasquez, do you understand what you've been charged with?
Yes.
And to this charge, Mr. Vasquez, how do you plead guilty? Not guilty, no contest.
No contest.
Now, you plead no contest freely and voluntarily?
Yes.
And are you pleading no contest because you do not wish to fight or contest the charges? Okay, yeah, okay, so let's see, this is a Class B misdemeanor driving while intoxicated.
Yes,
And you pleading no contest, is that correct?
Yes,
All right. Now, Mr. Vasquez, I have before me another document that is titled misdemeanor plea admonishment. Gotta check off that, the box below that, not the.
I asked the state to make that correction.
State was busy. All the other were for sure.
I acknowledge that I was wrong.
Okay, now, Ms. Vasquez,
Where's my wingman?
I have before me a document that is titled misdemeanor plea admonishment. Recognize this document?
Yes, sir.
Now, Mr. Vasquez, the box says check the X. This is a Class B misdemeanor, DWI. The range of punishment is minimum 72 hours in Jefferson County Jail to a maximum of 180 days and a fine that does not exceed $2,000. Do you understand the range of punishment?
Yes, sir.
On page 2 of the same document, there is, let's see, there are a set of initials, two sets of initials. One is your attorney's initials and the other initials, AV, or
Yes.
did you place your initials on this document?
Yes, sir.
On page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
On the next document, it's titled charcoal certification of defendant's right of appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are two boxes that's checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that
Yes,
statement?
sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to appeal.
Yes, sir.
Do you understand that statement? I also have before me a document that is titled Discovery Certification. Do you recognize this document? And is this your signature on the line that's titled defendant? Now, Mr. Vasquez, before you sign an initial to all of these documents that I just showed you, did your attorney go over these documents with you?
Yes, sir.
Excuse me. And Mr. Vasquez, again, before you sign and initiate these documents, your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Vasquez, are you a citizen of the
Yes,
United
sir.
States? State. I have before me states exhibits 1 and 2. State you like to offer states 1 and 2.
Yes, sir.
Any objections?
No objection, states 1 and 2, Judge.
No objection, states exhibits 1 and 2 are admitted. Mr. States exhibits 1 and 2 are admitted. And Mr. Burbank, you advised in counsel, Mr. Vasquez, is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Vasquez, your attorney, Mr. Burbank, has advised in counsel. Are you satisfied with his representation?
Yes, sir.
Has he provided fully effective and competent legal representation?
Yes, sir, Your Honor.
Mr. Vasquez, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given, and I'll also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do.
And what is that agreement?
I say for a plea of guilty or no contest, state's agreed to recommend 30 days Jefferson County Jail and court costs. The defendant has credit for 3 days on this case.
3. Okay. And, okay. Let's see what this court cost is. Mr. Vasquez, the state is offering that you serve 30 days in Jefferson County Jail. You'll be given credit for the 3 days that you have already served. The court cost in this case is $407. Would you be able to pay the $407 court cost? Okay, now, Mr. Vasquez. Yes. I'm gonna show you a document that is titled affidavit of financial affidavit. Did you show this to you? Do you recognize this document?
Yes, sir.
Now, the financial information on that document, is it still true and correct today?
Yes, sir.
Okay, now, Mr. Vasquez, the court is gonna find that you're indigent because you was found to be indigent on this date, based on this affidavit. So based on the affidavit, your the court cost is going to be waived pursuant to Article 42.15 of the Code of Criminal Procedure. So it's finding you indigent. Now, Mr. Vasquez, you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay. Mr. Vasquez, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Vasquez, we'll move to your next case. The next case is cause number M333398. Case is style State of Texas versus Alfonso Vasquez. Mr. Vasquez, I have before me a document that is titled Information. And this information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Vasquez, it alleges that you, Alfonso Vasquez, on or about April 24th of 2022, while you in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed to Class B misdemeanor offense of driving while intoxicated. Mr. Vasquez, you understand what you've been charged with?
Yes, sir.
I've noticed the information just say DWI. Did they charge him with an open container? Because that's what's on this document. It's not an open container.
It's not, we don't allege it in the information.
I know. I just want to make sure that the judgment comes out that says DWI and not with an open container. But okay, that's fine. Now, Mr. Vasquez, to this charge of DWI, how do you plead? Guilty, not guilty, no contest? No contest?
Yes, sir.
Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
I have to change it on this here. Mr. Vasquez, I also have before me a document that is titled Misdemeanor Plea Admonishment. Do you recognize this document?
Yes, sir.
And is this your, on page 2 of this document, there's a set of initials. The the AV, are those your initials on the line that's titled no contingent, which means no contest? Third page of this document is the signature above the top of this document that's titled defendant. Is this your signature?
Yes, sir.
On the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes that's checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir. Your Honor.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir. Your Honor.
And Mr. Vasquez, I also have before me a document that is titled Discovery Certification. You recognize this document?
Yes, sir. Your Honor.
And is this your signature on the line that's titled defendant?
Yes, sir.
Now, Mr. Vasquez, before you signed and initialed all of these documents, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State I have before me states exhibits 1 and 2. State like off states 1 and 2.
Yes, Your Honor.
Any objections?
No objection.
No objections,
State 1 and 2, Judge.
No objection. States exhibits 1 and 2 are admitted. And Mr. Burbank, you advised and counsel Mr. Vasquez in this case as well. Is there any evidence that he's currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Vasquez, your attorney, Mr. Burbank has advised you in this case. Is there any, are you satisfied with his representation?
Yes, sir.
Has he provided fully effective and competent legal representation?
Yes, sir. Your Honor.
Okay, Mr. Vasquez, I will accept your plea of no contest. I will find that your plea and waivers was freely and voluntarily given. I also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, you have a plea bargain agreement in this case?
Yes, Your Honor.
And what is that agreement?
In exchange for a plea of guilty or no contest, states agreed to recommend 30 days in Jefferson County Jail. And court costs, has credit for 2 days.
Doing this one. Okay. Okay, Mr. Vasquez, the state is offering that you serve 30 days in Jefferson County Jail. You'll be given credit for the 2 days that you've already served. The court costs in this case will be waived because the court has previously found that you are indigent. And based on that finding of indigency, the court costs will be waived pursuant to Article 42.15 of the Code of Criminal Procedure. Now, Mr. Vasquez, do you understand the state's offer?
Yes, sir. Your Honor.
And do you think that the state's offer in your case is fair and just?
Yes, sir. Your Honor.
And do you accept the state's offer?
Yes, sir. Your Honor.
Okay, Mr. Vasquez. Also state, I see here on the plea form, the state is dismissing cause numbers M32358, cause number M333400, cause number M331524, and cause number M331522.
That's correct.
Is that correct? And I have before me, Mr. Vasquez, in cause numbers M333400 and cause number M331522, motions to forfeit those weapons. And Mr. Vasquez, do you recognize this motion in cause number M333400?
Yes, sir. Your Honor.
And is this your signature on the line that's titled defendant?
Yes, sir. Your Honor.
And in cause number M331522, I also have a motion to forfeit the weapon. And is this your signature on the line that's titled defendant?
Yes, sir. Your Honor.
Okay, now, the first motion, cause number M333400, that weapon will be forfeited to the Groves Police Department.
Yes, sir. Your Honor.
And in the second motion, cause number M331522, that weapon will be forfeited to the Beaumont Police Department.
Yes, sir.
And you're asking the court to grant these motions?
Yes, sir.
Okay, and before you sign these motions, your attorney went over these motions with
Yes,
you.
sir.
And everything in these motions is true and correct to the best of your knowledge.
Yes.
Okay, the court is going to grant the motions to forfeit the weapons to the agencies that's named in the motion. Now you understand the state's offer.
Yes, sir.
You think that the state's offer is fair and just,
Yes.
and do you accept the state's offer?
Yes, sir.
Okay, the court is going to follow the plea bargaining agreements in these cases. So at this time, Mr. Vasquez, you're gonna stand on the X in front of your attorney, follow the directions of our clerk. Once you finish following her directions, then you'll follow the bailiff and you have a blessed day. Jefferson County Court at Law number 2 is back in session. The court is in session in cause number M327-528. The case is styled the state of Texas versus Jacob Matthew DeQueer. Mr. DeQueer, is that your full name?
Sure.
How are you doing, Mr. DeQueer?
Good, how are you?
I'm doing fine. Thanks for asking, Mr. DeQueer. You're represented in your case by your attorney, Attorney Dustin Gilmore. Attorney Gilmore, how are you doing?
Great, Judge. How are you today?
I'm doing fine. Thanks for asking. And the state is represented in this case by Attorney Eric Porter. Ms. Porter, how are you doing?
I'm doing great, Your Honor.
Okay, now this is a case that was set on the court's jury trial docket. Now, Mr. Galmore, are you waiving your right to a jury trial?
We do, Judge.
And the state, are you waiving your right to a jury
We
trial?
do.
Okay. The state, would you please, well, state, are you ready?
We are ready, Your Honor.
And defense, are you ready?
Ready.
State, would you please read the information?
Okay, in the name by the authority of the state of Texas comes down to undersigned Assistant Criminal District Attorney, Jefferson County, Texas, on behalf of the state of Texas, and presents into the County Court of Law of Jefferson County, Texas, that in Jefferson County, Texas, Jacob M. DeCour, hereafter styled the defendant hereto on or after July the 4th, 2020, did then and there intentionally, knowingly, and recklessly cause bodily injury to another, namely Carly Willett, hereafter styled the complainant by spraying complainant about the face and body with pepper spray. And at the time of said assault, complainant was a person with whom the defendant has had a dating relationship against the peace and dignity of the state.
Mr. DeQueer, how do you plead?
Not good.
Not guilty. Okay. State, would you like to make an opening statement?
Oh, we have no open statement, we waive it.
Defense?
Wait.
State, you can call your first witness.
State calls Mrs. Kimberly Willett, Carly Willett.
Harley, you
Carly Willett.
Harley Willett. Harley Willett. No response.
State, would you like to call another witness?
No, state has no witnesses to this.
State rest, you have a statement you'd like to make?
No,
No statement?
Your Honor,
only a statement, yeah. We made attempts.
multiple attempts to contact complaining witnesses in this case. We sent letters out, we made phone calls, one of which was today. The number was disconnected. Say your best.
Okay,
Move for instructed verdict, Your Honor.
okay, that motion will be granted. Instructed verdict will be granted. Mr. DeQueer, you are acquitted of these charges. You'll be given a copy of the judgment in a few minutes. Just have a seat and your attorney will get a copy of that judgment. You're free to go. You have a blessed day.
Judge, before I go, Ms. Richard is here. She got on Zoom and came.
Okay, we starting on Mr. Well, we got a couple of cases before, so that case will be
They should
reset.
be released.
Yes,
Thank you.
okay. Let's get the we're gonna have, the jury is gonna take up that section, huh? Let me do this here. Hold on a minute. Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to County Court at Law Number 2 today because we're set to have a jury trial, and you're here for jury service. You will be examined for inclusion on a jury trial. The jury trial that we have is a criminal jury trial. Our court hours are normally from 9 to 5. However, because we have large dockets in the morning, we usually start at 1:30 to 5. Whether you are selected as a juror on this case, you're performing a significant service which only free people can perform. If you are selected, this case will be tried expeditiously, consistent with justice, which require a careful and correct trial. If selected, the jury, unless otherwise instructed, you will be permitted to separate for recess, for meals, and at night. And I would be remiss if I didn't tell you that my name is Judge Terrence Holmes. Now, I must administer to you the first of 2 oaths. So at this time, I need each one of you, I need everyone to raise your right hand. And then after I finish administering the oath, I need each and every one of you to say, I do. Excuse me. Do you and each of you do solemnly swear or affirm that you will make true answers to such questions as may be propounded to you by the court or under its direction, touching your service and qualifications as jurors, so help you God? Okay, you may put your hand down. The law requires that each of you possess certain qualifications before you may be considered for service as a juror. Also, there are certain excuses and exemptions some of you may wish to claim. But first, I would like to determine if all of you possess the qualifications for service on a criminal jury. It is very important that you answer these questions carefully and truthfully. If you do not, the lawyers and I discover later on that you did not answer truthfully, then, and if you're seated on the jury, the case could be retried and you may be held in contempt of court. That is, you can be placed in the Jefferson County Jail for up to 180 days, which is 6 months, and be given a fine up to $500. Now, the way that I'm going to ask the questions is as follows. I'm going to ask a series of questions. I do not want you to answer those questions out loud individually. I just want you to answer the questions to yourself. And when I finish asking the last question, I will then say, is anyone disqualified under the law? And if you think that you are disqualified under the law, I'm going to ask that you come up before the bench so that we can discuss the matter more privately. And to be more specific, when I say more privately, I will turn off this mic and I will press this button for our noise device. Okay, does everyone understand? Okay. My first question except for failure to register, or you're a qualified voter in this county and state under the Constitution and laws of this state. Have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Are you presently insane, or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a petty juror for 6 days in the preceding 3 months in a county court, or 6 days in the preceding 6 months in a district court? Now, this last question that I'm going to ask, by law, we have to ask the question. I'm not trying to pry into your personal affairs. And the question is as follows. Are you presently insane, or have you been declared insane by any mental health or judicial official? Is anyone disqualified under the law? If you think you may be disqualified, just please raise your hand. Let the record reflect that no one on the panel has raised their hand. So at this point, they meet the qualifications. Now I will move to exemptions. Now, I would determine if anyone who is otherwise qualified to be a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required to claim them. If one of these applies to you, but you still desire to be considered as a juror, just please remain seated after I ask the final question. And I will ask the final question in the same manner that I asked the final question when I was trying to determine whether or not you're qualified. And that question is there anyone here who will be claiming an exemption? First question. Are you over 70 years of age? Do you have legal custody of a child or children under the age of 12 years, and jury service would necessitate leaving the child or children without adequate supervision? Are you a student in a public or private secondary school? Or you're enrolled and in actual attendance at an institution of higher education? Are you an officer or an employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petty juror in the county during the past 3 years? Or are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? Or you're a member of the United States military forces serving on active duty and deployed to a location away from your home station and out of your county of residence? Now, If any of these exemptions apply to you and you would like to claim one, just please raise your right hand. Let the record reflect that no one on the panel is claiming an exemption. Now I will move to excuses. If any of you feel there's a reason why you cannot sit as a juror, then after I finish stating those things that you can use as an excuse, just please raise your right hand when I ask if anyone is going to claim an excuse. A juror may be excused for observation of a religious holiday upon completion of an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties, that is, without the consent of the state and the defense. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone on the panel who will be claiming an excuse? Okay. Let the record reflect that no one on the panel is claiming an excuse. The record should reflect that all the jurors are qualified, no one is claiming an exemption, and no one is claiming an excuse. Mr. Hopper and Mr. Matus. You have a motion? The motion. The motion. You said.
I can make it orally.
You can make it. Okay. Okay. You may have.
Your Honor, we would like to orally make our motion of election to punishment to the judge.
Okay, and you have a written motion as well. Is that
We
correct?
have a written motion.
Okay. All right. Say give any objections.
Okay.
Okay. No objection. Your or motion, your written motion will be accepted.
Thank you.
All right. Court is in session and calls number 23CCCR 0020. Case of style of state of Texas versus Daniel Troy LeBlanc. Let the record reflect that the time now is 3:47 p.m. on today's date of August 15th of 2023. The defendant, counsel for the defendant, counsels for the state, and all members of the jury panel are present. Again, ladies and gentlemen of the jury, good afternoon. I would like to again welcome you to County Court at Law number 2. You have been summoned here to this court as a prospective juror in a criminal case. The defendant, Daniel Troy LeBlanc, is represented in this case by his attorney, Ryan Matuska. The state is represented by its assistant district attorneys, Attorney Kobe Hoffmeyer and Attorney Erica Porter. The court reporter is Miss Ada Christie. She will be taking down everything being said, so speak up when you are answering or asking questions. The bailiff is Mr. Charlie Porter. The defendant stands charged by information with the Class A misdemeanor offense of terroristic threat, family violence. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not meddling into your personal affairs, but are trying to select fair and impartial jurors to hear and decide this particular case. If at any time you would prefer to answer certain questions outside the presence of the panel, just say so, and I will ask you to come up to the bench to discuss the matter more privately by placing this noise sound device on. Is the state ready to proceed?
That's ready to go.
Is the defense ready to proceed?
Yes, sir, Your Honor.
Okay. Mr. Porter? You have a minute. Mr. Hoffmeyer, the panel is yours. You have 30 minutes,
Yes, sir.
and I will be keeping the time.
Thank you. Please, counsel. How y'all doing this afternoon? All right, now, well, I apologize, it's out there and wait, for 10:30. I apologize, it moves that way, we have to take care of business prior to we actually get the picture here is on board. We get to talk to you, all right? Now, I'm gonna tell you a little bit about myself. My name is Kobe Hopper. I'm an assistant district attorney. I'm one of about 25 assistant district attorneys that work at the pleasure of Honorable Keith Gibbons as a former federal magistrate. All right, he's the elected official, the elected DA. So we work at the pleasure of me and Miss Erica Porter, who's sitting with me. We're assigned this particular court, County Court 2. Okay, now County Court number 2 prosecutes misdemeanor cases. All right, we prosecute in Class A and B misdemeanor. District courts prosecute felony. Okay, so we're only going to hear cases that deal with misdemeanor. And the judge already went over that, kind of told you what kind of case is going to be. I'm going to go over the elements of it. We're going to kind of talk about the law. We're going to talk about feelings about the law. Okay, I don't mean to pry like the judge said. It's not anything like getting in your personal business. At any time, as the judge said, if you don't feel like answering a question, you'd rather do it in privacy or from the bench. We do that all the time. We'll do that afterwards. Okay, all you have to say is like, I'd rather not answer it out loud. Okay, and we'll do that after. All right, so we won't make them comfortable anyway. Okay, now we're talking about terrorist threat and the violence. Okay, has anybody ever heard that before? Miss Pennington, Dixon Pennington, is that right? Okay, you ever heard what terrorist threat and violence? Okay, now when we see terrorist threat, you don't think it's something like, that it's like a terrorist bombing or something like that. And that word kind of invokes certain things. You understand that? I'm not talking about international terror, all right? We're talking about terroristic. And I'm going to give you the elements of it. Now, Ms. Scott, I said that right? Okay, what did you think when you saw terroristic threat? As I explained it, like, international terrorism or something like that. Now, that's not what we're dealing with here, okay? We're just talking about threats and as you can see in a domestic relationship. Okay, we're gonna go over some of those things about that and what qualifies as a domestic relation. Right, state of Texas has decided that that amplifies a charge, meaning if it's just a terroristic threat that it didn't involve a family member or a household member, then it would be a class B misdemeanor. Okay, but because it involves a family member or former family member or a household member, it's up. Okay, because family violence, as what we've seen, is it has the propensity to escalate. Okay, and that's why the state of Texas is taking along with that. Okay. Now, let me go over that. These are the elements I have to prove. Now, I'm the state of Texas, all right? In a criminal trial, who has the burden of proving each and every one of the elements beyond reasonable doubt? Mr. Frederick. Prosecution, state, me. I've got, the defendant does not have a burden at all in a criminal trial. I've got to prove each and every one of the elements beyond a reasonable doubt. And that's a good thing, all right? Because it's a criminal case and we're talking about liberty. Now, we're not talking about preponderance of the evidence. Okay, that's like in a civil case. That's about money. We're not talking about money. Okay, in a civil case, it's just a little bit more than the other side. All right, it's beyond a reasonable doubt when it comes to a criminal case, and I've got the burden to prove that. I take that burden. If I don't prove each and every one of those elements beyond a reasonable doubt, what do you think the result would be? What would it be? Not guilty. Okay, right? Okay, see what I'm saying? It never changes. Always with me. Right, as the state of Texas, all right? Now, let me go through the elements real quick. I've got to prove the defendant on or about a certain date in Jefferson County, Texas. That's jurisdiction, okay? It has to occur within our city county limits, okay? Did unlawfully, and this is where it gets a little bit more specific. With intent to place the complainant in fear of imminent serious bodily injury. Okay. Threatened to commit an offense involving violence to the complainant. And at the time of the offense, the defendant and the complainant were family or household members. All right. Does everybody see those elements? Okay. Those are the ones that I'm required to prove to you. You're making on the panel beyond a reasonable doubt. Okay. Now, first four. The defendant on or about a certain date in Jefferson County, Texas, and unlawfully, that's pretty easy, okay? When you get down to the gist of what this case will be about, it will be about whether or not there was an intent to place the complainant in fear of imminent serious bodily injury, okay? And then the next one will be threatened to commit an offense of violence against the complainant, and at the time, they were family members or household members. I'm going to go through some definitions for all of those, but everybody can read those, right? Everybody understands, we're going to get into it a little specific, but you're okay, you're with me so far, right? All right, I'm always taking with you to make sure I'm not going too fast because I talk fast, I apologize. Try to get everything I can in, all right? So if you don't understand anything I say, you don't understand the question, I got to skin. Tell me, hey, repeat that, please. I don't know what you're saying, okay? Now, imminent. What do you think imminent means, Miss Garza? Okay, what about you, Mr. Strong? What do you think imminent means? Right now, that's good. Everybody here, Mr. Strong said right now, okay, like impending, is that fair to say? Or like coming up, right? Okay, means ready to take place, okay? Imminent is impending, approaching, okay? Or probable, right? Okay, now that's an important part of this, imminent serious bodily injury. All right, everybody with me? Okay, now, serious bodily injury, what do you think that is, Ms. Roy? Okay, and when we're asking that, is it, what kind of injury would it be? Okay, now, it's instructive, and thank you, Ms. Roy, instructive, I'll give you the definition of what a bodily injury is. Okay. Bodily injury in the state of Texas means it's a fancy word for pain. Okay, it does not have to cause visible injury. It does not cause you to bleed. Okay, or it doesn't require a hospital visit. It's the bodily injury. However, serious bodily injury under our law is a more protracted injury. You understand what I'm saying? It's more obviously because we're saying it's serious bodily injury. Now I'm going to give you the definition of what the law is. Okay. It means bodily injury that creates either substantial risk of death or that causes death. Okay. Serious permanent disfigurement. Good. And protracted loss or impairment of the function of any bodily member or organ. Okay, so we're talking very, very serious. And obviously, those kind of things, hospital, right? Loss of limb, those kind of things, right? So we're talking serious bodily injury, not the lesser bodily injury. Everybody with me? Okay, that's what the law said. So you have to place that person in fear of that serious, imminent serious bodily injury. I'm getting more of what I'm saying. Like an imminent threat was so much that it was imminent and it was serious. Now death is very serious injury. We all agree that's more than an injury, that's being injured, right? So threatening someone's life, you think that will qualify? Anybody disagree with that? Like if you're threatened to have an imminent threat of serious bodily injury that causes actually death, would that be qualified as serious bodily injury? As you can see, that creates a risk of death or that causes death. You see what I'm saying? There's a threat to someone's life. You think that would qualify? Anybody disagree with that? What about you, Mr. Jackson? Okay, you agree with that? Okay, everybody agree with Mr. Jackson? Okay, you look at this, all right, Miss, you look at me like, whoa. Okay, you good? You agree? Okay, you were looking, I didn't know if you were giving it side eye. So I'm not sure, but that's fine. I want to make sure that you didn't. Okay, yes, ma'am. Now, family members, who thinks, what's a family? All right, let's talk about you, Mr. McGuire. Okay. The state of Texas says within consanguinity, which is a big word and we don't need to talk about. Okay, but it's like family tree. Okay, that's the best way to explain that. Now, the state of Texas says, and anyone related within the third degree of consanguinity or affinity. Okay, that's another big word, but it includes a former spouse, right? So the state of Texas definition means like an ex-wife or an ex-husband, that's a family member under our law. Okay, everybody understand that? Even though technically you're saying, well, that's not my family anymore, but it is a former spouse, right? Because children may be involved. So the definition includes a former spouse. Everybody confused by that, or do you understand why that's in the law? Everybody got that? Okay. Now, also a household member, unit composed of persons living together. Now, some people don't think this is funny, but as far as the definition, say your college roommate, right? You live together in the dorm, right? If there's an assault or a terrorist threat, you are a family or household member under the laws of the state of Texas. Both of you use the same address, right? And you live in a household, okay? So that's considered family or household member. I got that. And then finally we have, and it's been expanded, is dating relationship, okay? Former dating relationship, whether you cohabitate or not. You understand what I'm saying? Dating violence has become big and the law has followed that, okay? That's not what we're dealing with here, but I just want to make sure you understand all those definitions qualify as family law. Okay. Now, offense involving violence. What would you say, Ms. Sandoval? What kind of offense would you think?
Whatever the person committed and it caused violence, hurt someone or.
Yes, ma'am. Could you give me a crime? You think you can give me an example of it? What about murder? Does that qualify? Meaning like the threat of murder, right?
Yeah.
And it was serious imminent. That would definitely, right? That's a crime of violence, right? Okay. What about another one? Can you think of one, Ms. Lewis? Well, put that. Okay, the first one. Okay. What about assault?
Yes.
What we call like an assault. Somebody gets punched. Let's just use a punch. That's an easy example, right? So everybody here, Ms. Lewis said fighting. So a punch is an assault, right? And would you say that's a crime with violence? Okay, so a threat to assault someone, right? Now, what about you, Mr. Avanzado? Can you come up with another one? What about sexual assault? Okay, that could be violent, correct? Right? That's another threat of violence. Right now, another one I'm going to give y'all an example of is aggravated kidnapping. All right, that's another big one, you know, it doesn't have to be exactly, but it could be violent if you kidnap someone with an intention to cause violence, right, to hurt them in some way, right? Okay, now, what about arson? Everybody know what arson is? What do you think? That's good,
Arson, burning down.
right? Okay, could that be an act of violence? Now, anybody can think of anything else? Now, that's what we're talking about when we say act of violence, a threat of an act of violence, right? Okay, now, is this a good law? Now, what I'm asking y'all about in this one, I'm gonna ask this, excuse me, I apologize, Ms. Barbarossa. Okay, what would, I'm talking about the law and the elements we're here for, terroristic threat, family violence. Is this a good law? Meaning, should we outlaw and not allow someone to threaten someone, their life, or threaten them serious bodily injury with an act of violence? Should we outlaw it? Okay, it's okay not to agree with the law. It's okay not to agree with it and say it's overstepping. That's kind of why we're here, right? We're asking you about the law, and it's okay to disagree with the law, right? Well, what do you think, Ms. Barbarossa? Excuse me, yeah, Ms. Barbarossa.
It's just a threat. It's a little bit of overstepping, but
Okay,
it's also good too.
okay,
I don't think you should be able to go around front of me that.
okay.
Right in the middle.
So you're in the middle with now, this kind of comes in with. Yeah, you've ever been told, you have 6 and stone, bury my bones, words can never hurt me. Okay. Now, there's one thing about that as far as words versus what? Actions, right? But if the threat is words of action, right? And if someone actually is like the elements where we're talking about threat of imminent serious bodily harm. Is that words? Is that like a First Amendment thing? Where you get to say what you want? Or can you place somebody in fear? Or are you overstepping their right? Well, I guess that's the question. Everybody get what I'm talking about? Anybody confused by that? I understand it's a gray area, right? Certain things you can say, but can you threaten a person to the point where they're fearful for their life? What do you think? You can, like, I mean, should we allow it? Should we say that's okay? As long as you don't touch them or that's where it gets kind of, you know, gray area, right? Okay. What do you think? Let me ask Mr. Kendall Lawrence, all right?
Depends on what the
Okay, what would it tell? What kind of-
I can have, I guess, be told for just about anything, but the thing is whether a threat comes too far, as in going into the description of what you're gonna do. That's.
Okay, did everybody hear what Mr. Kendall already said about descriptions of what they're gonna do, right? Now, words are words, right? But what else do you look at to determine if that, like you're saying, whether words are descriptive? Like what if there are violent things, right? What about in furtherance of? You do something in furtherance of the words that you use. What do you think about that? Is that something more, or is that shouldn't even be looked into? It's irrelevant.
If they start. So if they start showing signs that they're gonna do something
Okay,
of what they threatened, then that's.
okay,
Where the law comes.
okay. Yeah. So you're thinking like an act in furtherance. Is that fair to say? Everybody understand when I say that? But does it have to be any act? Because it comes from, well, the question is if you threaten someone with imminent serious bodily injury, and they think that that's possible, that qualifies under our law. Everybody understand that? Right? So, I mean, if you're placing someone in fear and you intend to place them in fear for that, haven't you completed the crime already, right? It's not, we don't wait until you commit the crime, then it would be another crime, wouldn't it? It's a threat of imminent serious bodily injury. You understand? So this is, the threat is the point of it, and it's terrorist threat, it's right there in the explanation and the definition. Okay, it's not whether or not they completed this, but they threatened it, and the person who was threatened believed it was imminent. Okay, so it kind of comes, you understand what we're talking about? It's what they believe. Okay, and was it imminent? Was it, were they scared? Right? Who gets that? Where do you get that information? What do you think this was? Who could tell you I was in fear? The person that was threatened, right? Is that right? Everybody hear that? Okay, so the complaint is what we call the complainant, okay, in criminal law. Okay, anybody got any questions about it? No, but it's important for us to talk about this because that's what the case is about. Okay? Now, what would you like to see in a terrorist trial to determine whether a person is guilty or not? Let's go. Give me some kind of evidence that you like to see. Okay.
Good,
Okay.
disfigurement.
So, okay, that would be actually, they went through, not the threat is what we're hearing. Now, if it wasn't, and now, if it was bodily harm and disfigurement, we wouldn't even be in this court. All right, we're talking about in district court and felony level. You see what I'm saying? Everybody understand why? And you're right, the threat of it, that's why, but if it went and happened, right, and we had enough evidence to prove that, it would be a felony, okay? That would be like an aggravated assault, right? Everybody understand? Okay, we're just talking about threat of it. That's what it's a class A was doing. Okay, now, Mr. Avanzado, what do you think you'd like to see? What kind of evidence would you like to see?
I don't know, witness or proof of.
All right, testimony, right? The witness is the person who can tell, like, Ms. Barboza said, the complaint, right? The person, they are the only ones who can tell you whether or not they were scared, like, for their life. They're the ones who had experience. I mean, now, I understood.
And then it becomes he said, she said.
True. But that's where it comes in their testimony, and that's what, testimony is evidence. Everybody understand that? Okay. Testimony is evidence. That's why somebody goes and stand, they take oath, tell the truth, the whole truth, nothing but the truth, all that. Okay. Now, Miss Woods, you're looking at me. You're looking at me with, I don't know about it. What do you think? Okay. That's
Okay.
fine.
You got 10 minutes.
Yes, sir. Now, video, all right, body cameras, all right, what do officers have when they come out on the scene, all right? Now, generally, what's not caught on a body camera, let you know, is usually not a crime because the officers come after something happens, you understand? So rarely do we get video of the crime. Now, we have a lot of cameras around more than we used to. Anyway. However, but the body camera of the officers is just something of what the officers did, okay? What about testimony we talked about? And then digital forensics. Everybody knows what everybody heard what like a phone number. Okay, that means everything that your cell phone did, receive messages, text messages where you send out, that can be downloaded by the police officer. Okay, using forensics. All right, that's kind of evidence. Would that be good evidence? Determine whether somebody was threatened in that.
Yes.
Now, CSI, law and order, raise your hand. Who watches CSI, watches NCIS, and all of the, who watches investigative discovery, one murder mystery after another, right? All right, everybody understand that's television, right? Good. Now, we don't have a lot of those, some machines and things are just television, right? And never in the history of criminal law has something been, the crime been committed, it's been investigated, it's been tried, and you're already in prison in 45 minutes at work. It just don't work that way. Which it was, all right? So it is longer, it is more tedious, all right? But it doesn't mean that we don't have to use what technology we have, okay, to investigate things. Everybody understand that? Within reason, all right? Somebody once told me that you could find, they had one on the other night where you found fingerprints on sand at the beach. That sounds right? No, okay. Now, All right, we're gonna go through this. Now, state's burden of proof is common sense. All criminal trials in the United States have beyond a reasonable doubt, okay? We use it every day, everywhere, all right? It's not insurmountable, it's not impossible to meet. Now, Miss Deli, what do you see? Sure. All right, is that a gun? Is that a puzzle over there? Okay, right? Now, is it missing pieces? It is, right? But this is the same as what a trial, right? It may be where it's missing some pieces, but can you not tell that that's a puzzle of a gun, right? You can tell what it is. It doesn't have all the pieces, but you can see enough of it to tell, right? That's a good example of how the trial works, okay? Now, reasonable doubt, all right? We used to be able to give you a definition of a long time ago of what reasonable doubt is. We no longer can. The state of Texas won't allow us to give you a definition of reasonable doubt. I can't tell you what it is, all right, but I can tell you what it's not. Okay? Tell you what it's not. It's not beyond all doubt, because what would that require? Think about that. What would it require beyond all doubt? Like I know for sure.
Videotape.
What about you being there personally?
Right.
Now, if you've been there personally, could you be on the jury? Where would you be? Not in that big box, be in that box over there, right? You'd be a witness, right? All right. So it's not beyond a shadow of a doubt. Now, a lot of people have heard shadow of a doubt, all right? That's a TV term. It's never been in law. Okay, that's from Matlock. All right, murder she wrote. All right. Okay. So now the best way to explain it is you'll know it when you see it. All right. You brought your common sense with you, right? You didn't, when they checked you for your metal detector downstairs, and they said, put your common sense in the bucket, we'll give it back when you walk out, right? Okay, so everybody's got common sense. Y'all have it, okay? You can all sit on a jury and determine it, right? You can determine whether there's reasonable doubt. Now, will anyone require the state of Texas to remove all doubt? Everybody knows that it's beyond a reasonable doubt and only deals with the elements of the case, the things I went over at the beginning. Okay? It doesn't have to do about, well, if a person's shirt was blue or it was light blue or dark blue. All right, that's not an element of the case. The element of the case is what beyond a reasonable doubt. Everybody get that? Yeah. Now, prior criminal jury service, that a bunch of people on it, and I appreciate y'all coming again. We want you all the time. Please come back. All right. But it looks like I'm going to ask some questions, Mr. Dab. You were on a prior criminal. I'm just talking about criminal jury.
In 5 more minutes.
Thank you, sir. Would you mind telling us a little bit about, and I'm going to ask everybody who's been on it. I'm just going to go over it quickly with you. What I'm going to ask you, was it in Jefferson County?
No.
Okay, it wasn't? Okay. And what type of case it was? I didn't. Okay. Now, were you able to reach a verdict? Okay. And did the judge or the jury assess punishment? I did. The jury did? Okay. Thank you, man. Appreciate it. Now, anything about that, you're serving on jury before, would it limit you or prohibit you from being a fair and impartial juror in this particular case? So listen to the facts and the evidence. Okay. Thank you, ma'am. Now, Mr. Scroggs, I believe you served on the criminal jury. You've been on 2 of them. Okay, what kind of cases were those? Murder trial? And have you saw?
Yeah, I saw it.
Now, did y'all reach a verdict in those cases? Okay, and did y'all assess any punishment or any?
First one was
No, did you? Okay, now, anything about serving those 2 jurors? I thank you again for your service. But, okay, you can sit, be a fair and impartial juror, sit and listen to these facts only. Is that right? Thank you, sir. Mr. Boyd, you also served on the criminal jury before?
Yes.
Where was that, man? Was it in Jefferson? Okay, how long ago was that? What kind of case, if you don't mind telling me? Was it a murder case? Okay, did y'all assess punishment or was it? Yeah, did. Okay. Thank you, ma'am. I appreciate that. Now, anything about that would prohibit you from being a fair and impartial juror. Thank you, ma'am. And Mr. Lear, did you serve on a jury? Would you tell me a little bit about it?
Charles, yes.
Okay. And did y'all reach a verdict in that particular case? And did y'all assess any punishment?
Yeah.
Okay, thank you, sir. I appreciate that. Now, you can serve on jury in this case. Put that one out of your mind and sit on this case and be a fair and impartial. Okay, thank you, sir. Now, Miss McGuire, is that you serve on a criminal jury before? Okay, will you tell me a little bit about it? Here, Joseph County. Okay. Did y'all reach a verdict in that case? Okay, did y'all assess any punishment? Thanks, sir. Now, ask that question again for you. Can you put that out of your mind and be fair and all? Thank you, sir. Anybody else that I missed? Everybody else? Okay, thank y'all so much. Now, important, anyone who cannot sit in judgment of someone on a criminal trial, right? This is important because that's what a jury does, right? It's not sitting in judgment of, your being, or you see what I'm saying, like your soul, all right? We're just talking about sitting in judgment, hearing the facts of the case and sitting in judgment. It's important why I ask that, because some people's religion won't let them sit in judgment, okay? And that's fine, and everybody's got a right to their religious beliefs. However, if you can't do that, we gotta know about it now, okay? Everybody understand that? We can't find out about it later, well, once we've gone through the whole case, and then we're like, well, I can't give them my religious belief. Okay, so I gotta ask that question now, okay? And I've had that on bigger cases where we've asked that question, and then we found later on at the end that, like sexual assault, child cases, or someone can't sit in judgment. Well, that means we gotta do it all over again, right? And we gotta put that child back on the stand. See what I'm saying? Yeah, and that's something we don't want to do. But that's not this case, all right? But that's why we gotta ask that. Okay? Now, juror's duty, okay? You decide the facts. You are the judges. You determine what happens, all right? The testimony and the evidence presented to you at trial. The judge is going to give you the law in what we call a jury charge. So you apply the facts that you determine, you apply to the law given by the judge, all right? And then you follow the law. That's it, all right? It's easy. Thank y'all very much for your patience. Thank you for listening and speaking with it. I really appreciate it. We look forward to trying the case for you. Thank you. Your Honor?
Yes,
No, no.
okay. You may proceed.
Yeah.
Okay.
Talk about this in a little more. You can go on.
Four.
Sorry.
Yes, ma'am. Just, if you could wait until we're finished.
Okay, that's fine.
Yeah, that's just clicker.
Judge, where can you get it? On this map? Yep.
If we got remote, we turn those on manually.
Hold on a minute. Okay, ladies and gentlemen, the jury, we're having some technical difficulties. We're gonna take a 5-minute break. You can all stand and follow the bailiff out into the hall. And there's some restrooms in the hallway. Everyone please stand for the jury.
Is that okay, Judge? Or the other? Okay.
Hey, you ready?
Ready.
Defense, you ready?
Ready, John?
You may be seated. Let the record reflect that the court is back in session at call number 23CCCR 0020. Cases style of state of Texas versus Daniel Troy LeBlanc. I'll let the record reflect Mr. LeBlanc is present in court with his attorney. Attorney Ryan Matuska. Let the record also reflect that the state is present with assistant district attorneys, Attorney Kobe Hoffbauer and Attorney Erica Porter. State, are you ready? Defense, are you ready?
Yes, sir, Your Honor.
Okay. Mr. Matuska, the panel is yours,
Thank you, Your Honor.
and you have 30 minutes. I'll be keeping time.
Folks, thank you for your patience. I wish we could have it set up a little easier, but just want to briefly introduce myself. Ryan Matuska is my name. I practice in Nederland. I practiced here for some time, about the last 15 years. Now, I'm here on behalf of Daniel LeBlanc. This is an important case. Daniel, I know some of y'all have been on some really important cases. A couple murders, a couple other big felony cases that y'all have experienced. It's just as important to Daniel. His family's here, his wife, his mother, and his grandmother have shown up in the back of the courtroom here. Just because this is a misdemeanor case doesn't make it any less important. Why jury? Why not just let police, prosecutor, or the judge decide? Mr. Dwyer, would you mind answering that? Looking at it from the outside. Yes, sir. I think you hit the nail on the head. You're his peers. We all know that everybody who shows up for jury duty isn't lawyers, isn't judges, doesn't have a ton of legal training, right? And that's a little scary, kind of, but it's also a good thing, right? We all have experiences that we bring into this courtroom, educations that are different. We just blend those together. Anybody feel like juries are a little scary for them? A little scary if you were sitting in this chair, or you could do it a different way. Anyone? I feel pretty comfortable with the jury system. Before you came into court today, had anybody known that you could be charged criminally and possibly all the way up to a year in jail for threatening language? Anyone? That surprised you a little bit. Has anyone seen the movie Minority Report? Tom Cruise, where they catch criminals before they commit the acts through psychics. been about 10 years, I think, since that movie came out. Maybe I'm a little dating myself. But it's a scary idea that we can charge people with something that we actually have rights to. What I mean by that are freedom of speech. Right. The objective versus the subjective. Anybody here have children? Anybody here married? Mr. Sherman? Most all of us. How do we talk to our family versus strangers? Same or different? Miss Duffy? Same? I respect that. I have to push a little harder with my kids sometimes. Mr. Lair, do you feel like it's the same with your family than with a stranger? No. Why is that? You have knowledge about each other, experiences with each other, right? Sometimes you could say something that a stranger wouldn't even have an idea of what that meant, right? Anybody else have that experience with their family? Yeah. Those of y'all with kids, and I have 3 of my own. Do you say things to your kids to get their attention once in a while that you would probably never say to anyone else? Yeah, sometimes we do that. I do that to get my kids' attention. So we have a system of checks and balances. We have sometimes corruption, and we have protections of our constitutional rights. That's why you all are here. That's why a jury, our forefathers have decided, is better than a judge or just some police officer who's accusing them. We value liberty. We value our rights. What are rights? I go to schools occasionally and I talk to some kids and they always ask that question, like, what are these rights you're talking about? Ms. Senior.
Right to say what you want to say, as long as you know it doesn't hurt anyone.
Just by being an American citizen. Ms. Lewis, what are some rights that are important to you?
To be able to speak freely, the right to be treated fairly.
And Mr. Is it Alvin? Yes. You agree or disagree?
I agree.
Why is that?
Just being able to speak my mind and, saying the freedom of religion, and freedom of speech.
A bunch of them.
Yeah.
And we kind of take them for granted sometimes, but when you say them out loud, you start to realize, wow. We really are lucky, aren't we? Not all countries, you can just say whatever you want, right? Read the news story about Russia the other day, and that was issue that they were talking about. You can't just say what you want because they will think what they want, right? And what's the problem with that? Ms. Dixon? Ms. Dixon, and Pennington? I'm sorry. Thank you. Yes, what's the problem with not having the right to freedom of speech and just depending on what the other person interprets that as?
There's no way your abilities, there's no way your ability to make informed decisions, there's no way your ability to be educated.
Yes. And we're relying on their subjective interpretation, correct?
Could be incorrect.
Do you see how that can be tricky with charging somebody criminally? Why is that?
You're taking away their voice, and you're putting them into a system that doesn't value their voice, and you're taking everything from them. Setting up for failure.
Ms. Garsden, you agree or disagree? What is that?
Because, if you have the freedom to say what you want. Right.
Now, just because you want to say something is different than saying something that's interpreted another way, right? I mean, we could say stuff any way we want, right? How could that be different than just saying something that we clearly know what that means? How is that a little bit? Would you maybe think or act according to something that wasn't meant? Are there different ways that people perceive the way we or what we say?
There's different ways. You can like, what a person says, can be. Like someone can think different what someone's saying.
Exactly. You could say something metaphorically, right? And then that would be interpreted much different sometimes. Is that also a problem when you're charging somebody criminally with a speech? Or is it not? It's, you know, not trying to put words in your mouth.
I mean, there could be a problem. Person that doesn't feel the same way as what you're trying to say.
And we heard, I believe, is it Scroggs? You talk about imminency. Is that you? Define for us what you said earlier. Imminent to you was right then.
It's gonna happen.
And that's the word that our legislature has decided to use is imminent. Anybody disagree with right then? That's okay if you do. We're on the same page about imminency. If we are charging somebody, Mr. Frederick, with what they say, and we're saying that it's imminent, could you give us an example of something in your mind qualifies?
If I got up and said that I'm gonna beat you to a pulp,
That would be assault
that would be.
that you would describe in detail, beating me to a pulp. That's what, no, I appreciate it. That is exactly what I would probably say. Anyone else have a good example? Ms. Barbosa, could you give us a different example of something that would be speech that would be imminent like that in your mind? Will you? Yes. Now, if I told my kid that, what would they say? Come on. And give that a good. Right? Depends on our audience. Does it also depend upon situations involved with those people? Could people manipulate what's said? Is that a possibility? Does that scare you in regards to charging somebody criminally with speech again? Because how easy would it be to say, I was scared? So, Ms. Roy, we've got, I'm gonna beat you to a pulp. And we've got, I'm gonna kill you. I'm really warming up to you guys, right? Can you give me an example of something you think is imminent in his language?
It's the way that it's interpreted, meant to make believe.
So if Ms. Barbosa says she's gonna kill me, I may shrug that off. Mr. Frederick may say, I'm gonna beat you to a pulp. I may say, oh,
But it may be in a lingo, they may use that. It's just a term to get your attention,
okay, that's true.
just
Absolutely.
to get your attention.
just to frighten
I
you.
can also say, oh, you make a mistake.
So what's the difference between frighten you and get your attention? Using the same language.
Body gestures, tone, anger, mentality. All of those play factors.
Okay. And would what you're saying you're gonna do play a factor? Meaning, if what I'm saying I'm about to do doesn't say imminent in your mind,
It depends on the temperament. It depends on that attitude. To Weigh out and look at him and see, is he really gonna do what he's saying he's gonna do, or is he just talking?
okay, thank you. Miss, that, can you give me a time frame in imminent? Does it have to be right then and there? No? Tell me. What do you think?
foresee future, like for example, it's not, after long period of time. It's something that somebody would expect to happen soon, but that doesn't have to be right now. Like more likely it's going to happen,
Okay,
but it doesn't have to be right now.
why is that?
Why is that?
Mr. Hoffmeyer read to you law. So why could it be over a period of time?
Okay, because sometimes we say like we're going to do something and we don't do it right away. But we are thinking about it, so it's in our mind. So, it depends about the situation, but to me, it doesn't have to happen right now, but more likely it's going to happen soon.
Okay, thank you for sharing that. Did Ms. Pennington?
I think that's perfect.
You agree or disagree with that in the word imminent?
I disagree, I think imminent means that it's gonna happen immediately.
Why is that? Just because of the way it's worded?
Well, one, the definition of it, to the actual law itself, and then if someone is in imminent or immediate danger, then it's not going to happen later on.
Thank you. Ms. Frederick? You have two choices here.
I think imminent is just mean probable.
Problem, okay.
Not, there's no specific time frame associated with it. And that means that the likelihood of it happening is very high.
Okay, not time wise, just more problem. Okay, is it Ms. Garza? Do you agree or disagree? There's no right or wrong answers. Right then and there, or it could be over a period of time. Okay. And Mr. Cross? It could be over a period of
It could
time.
be over a period of time, but I still say it's right, it's coming right there. I mean, it's coming, but
Yeah.
it could be not right this second, but it could be a few seconds later, and you turn it back. It could be, but that's. Yeah,
Okay.
that's good.
Thank you, Ms. Roy.
Well, I agree that it can be immediate. Right in that, because you said it, you shouldn't be able to do it.
Okay. So you're going on the imminent side as a media, okay. Mr. Lear?
I feel like, yeah, that's imminent. Might not be right now, but it's gonna happen,
Yeah,
so I kind of view it that way.
okay. How do you guys interpret that statute? That's why I'm asking. You guys, are the judges, the lawyers write the words imminent in there. You guys can interpret that. Okay, thank you. Mr. McGuire? Ms. Single?
Says it's a possibility, it's gonna happen sometime else.
Okay, thank you. Ms. Lewis?
Someone could say, the next time I see you. It can be the next day, next week, but it's gonna happen the next time I see you.
It's how you feel that danger, right?
Yeah, so if someone says, the next time I see you, it's gonna be, so they will be imminent when they see. You.
Okay, and Mr. Avanzado?
I mean, I just say it's, something that's happening, we're in the process of that. It's
Okay, and Ms. Barbosa? Okay,
It's not my thing, it's just a.
it's okay if we disagree. That's why we're here. That's the beauty of the jury. Okay, thank you all very much. Mr. Alfaro did a good job of going through here. I'm gonna skip through. I know it's hot outside. You guys want to get out there? Enjoy it before it's gone. But as a defender, why is my job important? And would our system even work without a defender? Yes, no?
No.
Punch you to a pulp and kill you, that's fine. But if our system didn't have a defender, we wouldn't probably need much of a prosecutor, would we? We have an adversarial process. Sometimes that's hard, and you guys have a lot of experience on jurors, and you've seen that. Because we want the truth, right? All of us want the truth. It's frustrating when we can't get to the truth. But Mr. Hoffmeyer and I, that's our job together, is to hopefully come up with that. But we need y'all. So sitting here today, guilty, not guilty, or not sure?
Not sure.
Not sure?
Definitely, not sure.
Not sure?
Definitely not sure.
Yeah, I'm gonna stop you guys there. It's a trick question. Why? Presumption of innocence, right? Why is a presumption of innocence important on this stuff? Even though we're sitting in courtroom, we know things have happened to get us here, but we have to say presumption of innocence by law, right? You agree or disagree? Okay. Mr. McGuire?
Yeah, 10 minutes.
That's the only lawful authority needed to find a fellow citizen not guilty. That is it. Any one of us sitting in this defendant's chair here, where Mr. LeBlanc is, that is it. That's the country we live in. Everybody okay with that? Okay. It lasts through the entire trial. Then you guys get to the back and make a decision one way or the other. And that is the government's burden. The government must prove each and every element that they're presenting you with beyond a reasonable doubt or simple. Try again. Let's do another case another time. Do it better. You guys told me a lot about your legal training and education, so I'm going to give you some of that. But I want to talk about the legal standards real quick. We have 5 main legal standards. And we saw a puzzle Mr. Hoffmeyer showed us for trial. He said that's kind of what trial is. But who would get on an airplane if the pilot told you there were missing pieces named? Not too many. I know I would. I don't really like to fly, but I've done it a lot. But it seems crazy when I think about it. Like I'm trusting strangers to fly me hundreds of miles an hour where I want to go and can't. Puzzle pieces are important. And I'm gonna get you up there, but I'm gonna start at the bottom. Now, reasonable doubt is the very minimal level of proof that we need for police to stop you on the street. It must be supported by specific reasons. You actually have to articulate why you're doing this. It's not just. We think, some of us think, I sometimes think, oh, that's okay, just stop and see what's going on. We have reasonable suspicion there. How much proof does that take? This seems low. Put it in your hunch and you have to. How much proof would you think that would take? It's not even 50%, we know that.
Beyond a reasonable doubt.
Well, we're not there yet. This is just the very minimal for a police officer to question you on the street.
He thinks something's happened or he committed a crime, I think he has the right to stop and question you or look for documents.
But how much? It's gotta be objective, right?
Right.
So a little bit more. How do you feel about that?
Let's say based on what information he needs, you should supply that.
Okay, so a little bit of actual substantive information or data of some sort or personal knowledge, correct? Okay. Now we get to probable cause, and this is where you can actually be arrested. You can be searched. It's defined as a relatively high level of suspicion involves a fair probability that evidence of a crime will be found. Most of y'all heard that probable cause. It's probably the most common that we've heard. And that's a little bit more than reasonable suspicion. Now, this one's easy. Civil cases, some of y'all have been on, we know you have to cross the threshold of 50%. Scales have to be a little bit more on this side or the other. We call that the 51% rule. We can define that pretty easy. We can also take your money, guns, property, home. The government can take a lot of these things, or other parties can take these things based upon that. But clear and convincing evidence is higher than that, and we define that. We don't define beyond a reasonable doubt, but we define clear and convincing. In Texas, statutorily and judicially, it's defined as a firm belief that the allegations are in fact true. Why this is important is because the government can take your children away. Mr. Lair, how much proof would you think that?
5 minutes.
Yeah. Anyone with children? Mr. McGuire? How much would you feel comfortable as far as proof to take someone's children away if you were sitting there being the judge? A lot, especially if you were the person, right? Taking your children away, you would expect that high. Firm allegations are true, right? Firm belief. We don't define beyond a reasonable doubt. Just under it, we do define. This is the highest degree of certainty, even though we're in here for a misdemeanor. This is still taking somebody's liberty, taking somebody's freedom. This is something that stays with you for the rest of your life and it affects you. It's not defined. That's why I define everything under it. I have to get above clear and convincing evidence to get where we are here. Proof beyond a reasonable doubt requires the prosecution's proof excludes all reasonable doubt. Anybody have a life experience with this type of case? Or a domestic situation similar to where people are accusing each other of threatening behavior? Yeah. Okay. And nobody has any relatives or friends that they know of in a situation like that? Okay. Now, this is a misdemeanor. So if you did find proof beyond a reasonable doubt, could you sentence at the very bottom, just a couple of days? Everybody do that? Everybody okay with that? Or somebody said, no, if I found this to be true.
3 minutes.
Okay. So you ought to be open, your mind about that too. All right. I don't have anything else, but does anybody have any questions? Unfortunately, when you're picked, you can't ask any questions. Except by deliberation. All right, thank y'all very much.
Okay, ladies and gentlemen on the panel, I ask that you will follow the bailiff into the hallway. Some of you may be called back into the courtroom for some follow-up questions. At this time, the court will be in recess. Will everyone please stand as the panel exit the courtroom? Okay. Court is in recess.